The Restoring Territory Rights Assisted Suicide Legislation Bill 2015 deserves to be defeated. It deserves to be defeated on a number of grounds. First, the bill displays a sad misunderstanding of our constitutional arrangements. Secondly, it shows a complete disregard of the general basic ethical foundations of our society, where every single life is valued. And thirdly, it shows a disregard for the sensitivities of our Indigenous community, especially in the Northern Territory. Now, these three major points were considered by a Senate committee, which I had the privilege of chairing some time ago when we looked at the Andrews Bill. And in the years since, can I simply observe, the Constitution hasn't changed, the ethical foundations of our society haven't changed, and the needs of our Indigenous community haven't changed. Let's be clear on the constitutionality. The Commonwealth Parliament only exists because of the states coming together in a federation by a popular vote in 1901. The territories' governmental arrangements are only present because of federal government legislation. Local government at the state level only exists because of the will of the state parliament. Local government powers are determined by state legislation. Local governments are suspended, they're amalgamated, they're given less powers, they're given extra powers, all at the whim of a state parliament. So it is with territory governments and the Commonwealth. The legislatures in the territories only exist because of the Commonwealth Parliament designating the relevant powers, which, might I add, are specifically limited. Now, the bill before us erroneously asserts in section 3 certain objectives, and one of them is that the bill is designed to reduce Commonwealth interference. Well, given the fact that the territories and their governments are in fact fully the creatures of Commonwealth legislation, it is somewhat bizarre then to assert that the Commonwealth is interfering in its own creation. Then we are told the bill is designed to facilitate competitive federalism. Well, as I said before, the territories are not states. And might I just interpose at this stage, after the Andrews Bill was passed by this Parliament, the people of the Northern Territory were given a specific opportunity at a referendum as to whether or not they wanted to adopt statehood. That would have given the people of the Northern Territory the constitutional and legal right to have assisted suicide legislation. The people of the Northern Territory voted no. Let's be clear, the people of the Northern Territory voted no to the possibility of being granted statehood. Similarly, here in the ACT, it was the federal parliament that inflicted self-government on the ACT, because when it was put to the people of the ACT, do you want self-government in the Australian Capital Territory, the people of the territory voted no. And so these people, with respect, my colleagues who come in here and assert that there are somehow fundamental territory rights here that cannot be dealt with in the manner that the Andrews Bill did, overlook the fact that the people in the ACT shunned self-government. They didn't want it when they were asked, nevertheless it was imposed. And when the people of the Northern Territory were asked, do you want statehood? And part of the campaign was, if we granted statehood, we can then overturn, and legally they would have been entitled to do so, Mr Acting Deputy President. They voted no. And as a result, we are, I think, clear in the constitutionality of this matter that the issue of so-called states' rights clearly don't apply, and what's more, the people in both territories have deliberately voted against such a possibility. But those that do say that there should be no interference in the territory's capacity to legislate, I put this proposition to them. If, for example, the Northern Territory or the ACT sought to reintroduce the death penalty, would they say, let it rip, that's fine, I know we've got constitutional power in the federal parliament to override it, but it's their right, it's a territory right. So if they want the death penalty, they can have it. I trust we would live up to our responsibility in this chamber and say, given that we are at the peak, at the apex of the legislative authority as it relates to the territories, that we would seek to override their powers in that regard. And so this is not I trust for colleagues, a situation where you simply say territory rights prevail irrespective of the issue. My own view is that you should only intervene in exceptional circumstances, such as life and death matters. So, if the Northern Territory were to seek the death penalty, I would be one of the first to say, let's have legislation to ensure that that legislation is never enacted. So that deals with the issue, I trust, on the constitutionality and territory rights. And those that assert that territory rights should prevail over everything, I ask them to look themselves in the mirror and say, if the territory were to legislate for the death penalty, would they still be saying territory rights trump everything? I trust they wouldn't. Similarly, I trust that they will look seriously at the issue of what assisted suicide actually means and how it undermines the very fibre of our society. And let's be very clear, there are many good men and women with and without religion who have expressed very real concern about the concept of state-supported suicide. And let's be very clear, in my own home state of Tasmania, the state government, to its great credit, runs advertisements alerting people to the possibility of elder abuse, financial elder abuse, physical elder abuse. And as a lawyer before I came into this place, I knew that wills were disputed, that people were after the money that might be left behind, and you had greatly qualified psychiatrists on both sides of the argument asserting that the person making the will was of a sound mind, and equally qualified individuals saying they were of unsound mind. And so when we talk about safeguards, in inverted commas, for state-supported suicide, can I say to you they don't exist? And I will quote somebody that may be of interest to some of my colleagues, especially on the other side of this chamber. And I quote, "Is it possible to reduce to black and white on the pages of a statute book the circumstances and the safeguards in which we would allow the taking of a life? I have spoken to many experts, people engaged on both sides of this argument, and what has shaped my bottom line conclusion is the view that it is not possible to codify in a law the safeguards, the circumstances in which the extinguishing of a human life would be possible." So said former Labor Premier Bob Carr, and I agree with him. We have had many other people, a former Supreme Court judge in Tasmania, before whom I appeared, rest his soul, the Honourable Henry Cosgrove, who said in a very pithy submission to the Senate committee, and allow me to read the two long-established principles on which he relied. One, that private citizens are not permitted to destroy life. And the private citizen in this case would of course be the doctor. The private citizens are not permitted to destroy life. The state may do so, but only in carefully circumscribed circumstances. And secondly, that no person can consent to an assault on his person unless the assault is done in order to save life or health. As soon as we allow the concept to permeate our society, which would allow another person to be involved in the death of a fellow human being, we must have come to the conclusion that that life is not worth living. The concept of a life not worth living challenges to the very core our notions of civilisation. As soon as such a concept takes hold within the psyche of our nation, we will demean the value of human life. And I unfortunately hear some arguments in the community and sadly also in this debate about dying with dignity. That if people suffer from a particular disability, they somehow lose dignity. And it was for that very reason that the disability sector in the state of Victoria so passionately opposed the Victorian legislation in relation to state-supported suicide. They were appalled at the concept that people would start saying, well, if you've got that disability, well, of course your life isn't worth living. They were appalled by it. And the value of a human life is not dependent upon its particular circumstances. It is an inherent value that can never be taken away from that life, and we as a society should never say to a person who has come to a consideration, my life is not worth living, say, yeah, we'll be caring and compassionate, we'll help you get rid of your life. A caring, compassionate society would say, we understand where you're coming from, but despite your disability, despite the circumstances in which you find yourself, you are a valuable member of our community. We love you dearly and we will do everything we possibly can for you. And indeed, the committee that I chaired heard story after story. One person who had asked his brother, who was a medical doctor, to assist him to go a week before he died naturally. And a very poignant story it was, because the brother said no. And within that remaining week of that young man's life, he was able to reconcile himself to his mother and father. And as he was dying, he said to his brother, who was the doctor, thank goodness you did not agree with my request. These past few days have been the most valuable of my life. Another example is a young man who went on to marry and become a veterinary surgeon. He had been diagnosed with terminal illness in the palliative care section of the hospital, young bloke, no attachments at all, and was of the view that chances are, if state-assisted suicide was available to him, he may well have availed himself of it because he was under the misapprehension that he was going to die in a few days anyway. Whatever occurred, I don't know, but to the amazement of the doctors, he walked out of that palliative care unit, married, had children, and became a veterinary scientist, a surgeon. And so for every one story of an alleged painful death, we also have another story on the other side of the equation. And that is why these debates have to be determined, Mr. Acting President, on fundamental underlying principles and not the anecdotal evidence or assertion of one or the other side of the debate. And can I simply say that those that bring stories from the past, palliative care has come a long, long way. And I think we should be celebrating that and acknowledging that. And most people now in the medical profession tell me that you are able to have a pain-free death courtesy of all the treatments that are available. I wonder how many people know that about 5% of deaths which are assumed by the medical profession to have been caused by a particular issue, on post-mortem, it is found to have in fact been a different issue that occasioned that person's death. With all the best will in the world, misdiagnosis occurs. So I ask, why is it that in my former profession the vast majority oppose the death penalty? And I could give you and regale you with stories of the most heinous crimes. And people may well say, well, somebody who's committed all these heinous crimes surely has forfeited his right to remain in society. But we lawyers know that with all the best will in the world, there are miscarriages of justice. And that is why the vast bulk of lawyers are against the death penalty. Similarly, with the best will in the world, the vast majority of doctors acknowledge, despite all their training, despite everything they seek to do, misdiagnosis occurs. And that is why so many doctors, if not the majority of them, and I think it is a clear majority of them, oppose state-supported suicide. Because once you make a mistake with a death penalty, there's no turning back. Once you make a mistake with state-supported suicide, there's no turning back. It is final, it is over. Now, Mr. Acting Deputy President, allow me to quickly turn to the issue of Indigenous Australians. In the committee inquiry that I had the privilege of chairing, there were over 12,000 submissions from the community. Some 200 came from the Indigenous community. And without fail, each and every one of them pleaded with the Federal Parliament to pass the Andrews Bill, because within the Indigenous culture, the idea of euthanasia was anathema. And of course, euthanasia, state-assisted suicide, was a white man's idea. And there was very real concern that the Indigenous community, as a result, would stay away from the medical clinics throughout the Northern Territory. And what was very informative was that the committee, and I'll just read this bit, the committee heard convincing evidence from Mr Chips McAnulty, who was engaged by the Northern Territory Government to provide an unbiased and factual education campaign on euthanasia to Aboriginal communities following the enactment of the legislation. Mr McAnulty told the committee, even though he personally supported his own right to euthanasia as a non-Aboriginal, his experience in conducting the education campaign had brought him to the view that the Northern Territory Rights of the Terminally Ill Act should be repealed because of its potential to deter Aborigines from seeking prompt medical attention. Mr McAnulty expressed the view that the very existence of the Northern Territory legislation is a significant threat to Aboriginal health. Given the blessings that we now have in our community with palliative care, there is no need for state-supported suicide. And so in brief, Mr Acting Deputy President, the constitutional arguments asserted by the movers of this bill simply do not hold water, and if we deal with the principle of taking another human life, saying that there is such a concept as a human life not worth living, we undermine and indeed threaten the security of each and every one of us as individuals within a civilised society. And in particular, given that this seeks to override or allow the Northern Territory Parliament to deal with this issue again, the concern of the Indigenous community must also be front and centre. I oppose